think we have a few more folks that will be coming in a little bit later today, but we're going to go ahead and get started. I apologize about the situation with the elevator today. What doesn't kill you makes you stronger. So I apologize for that. Also, want you to know I drafted up a fabulous email to everybody who registered. I sent them maps and directions and free parking passes. Did that on Monday, and for some reason, none of you got it. So I apologize for that. I think everybody finally found it. I hope there's nobody still wandering around Grand Junction since yesterday looking for our event. Some other logistics. So one of the things we talked about during registration is the ability to sign up for a one-on-one meeting, 15-minute meeting with some of our experts and speakers today. And that'll take place from 4 to 5:30 at the same time we're showing the movie Switch. So that way you don't have to hang out 45 minutes and wait. You can watch the movies, slip out when it's your time for your one-on-one meeting, and go back in. We'll be in one of the 4 breakout rooms out here down this hall. And so I have a sign-up sheet that I'll have at the back of the table where I'm sitting that you can, during a break, come on up and sign up for your 15 minutes of time with one of our speakers and experts today. Some of you, as you know, yesterday, David and Kirby explained that the symposium is a joint effort between Garfield County, Western Slope COGA, and the Center for Local Government at CMU. And most of you know what Garfield County is, and you know what Western Slope COGA is, but you may not know what the Center for Local Government is. So there is information out on the table out there. I'd also encourage you to, can you not hear me, Tom? Were you doing this because you can't hear me? Okay, all right. Oh, let me know when you arrive. We have some other booths out here that you might find interesting. A lot of good information from Garfield County, and then community counts, which I think for those of you who don't have a community count in your community could learn a lot about how they're kind of blending and the maybe sometimes conflict between the industry and the citizens. So a lot of good information out there. I would encourage you to pick it up. The Center for Local Government is part of the Rediford Institute, and the Rediford Institute initially started maybe 4 or 5 years ago, David, with the Natural Resources Center. So when Mesa County was working on the, Mesa, I think Garfield County, working on the Dominguez Escalante Wilderness Study Area, we contracted with the Rediford Center to help us with the public input piece of that. Then they formed the Water Center, which has a lot of different educational opportunities for folks in the water area. They then added the Unconventional Energy Center, funded by FML dollars through Mesa County's FML district. And then in January, so just 4 months ago, we started the Center for Local Government. And we actually have 3 components to the center. We have a solutions clearinghouse, so local governments really from anywhere in the nation can contact us and share with us a challenge they might have, and we can help them find another community who has solved a similar problem that they can network with. We also have a Solutions Academy, and that's what this symposium is a part of. We do a couple symposiums every year and several webinars every month. So far, we focused on energy and economic development, but you'll be seeing us take on a lot of other topics in the near future. And then we have our Solutions Incubator. So this, if you're a community and you have an idea to solve a problem, but it's not been fully developed yet, you can work with some of the faculty and experts at the university. They can help with the research, the plan design, implementation, those types of things. So that's a little nutshell of what the Center for Local Government is all about. There's information out on the table. Please help yourself with that. Without further ado, we're going to head to our morning session. We've got Rebecca Watson here to speak for us. I'm really excited to hear her. Rebecca has more than 30 years of legal and policy experience in the fields of federal and environmental law, conventional and renewable energy, mining and natural resources. As Assistant Secretary for Land and Minerals Management of the Interior Department in the George W. Bush administration, she had oversight over 3 bureaus, including the BLM. Rebecca has also served as the Assistant General Counsel for Energy Policy at the U.S. Department of Energy in the George H.W. Bush administration. And she is Secretary of Western Energy Alliance, a trustee of Rocky Mountain Mineral Law Foundation, and serves on the boards of the University of Colorado Center of the American West, Volunteers for Outdoor Colorado, and Jefferson County Open Space Commission. In 2011, she was named the Distinguished Natural Resource Practitioner in Residence at the University of Denver Strum College of Law. So join me in welcoming Rebecca Watson.
Good morning. Hear me? Good. Trying this Garth Brooks headset, they told me to. So it's new. I'm going to try and cover a lot of territory this morning. I'm going to be talking about federal regulation of oil and gas, and we'll be looking at federal environmental laws that apply to oil and gas. I'll actually try and talk about 20 different laws. So it's going to be an overview, but just to make you aware what types of federal regulation are there, how it relates to state regulation, and then how it relates to your local communities. So I just want to give you a broad overview of those laws. All right. How does this one work? It doesn't seem to be on. I see. Okay. Okay, when you're talking about federal and state regulation, you have to take into consideration our form of government, which is federalism. We don't have one government doing everything. We have federal government, state government, local government, and that is laid out in our U.S. Constitution. We're going to take a look at the federal role in oil and gas regulation from two perspectives. Environmental laws that apply to everyone, no matter what land you're operating on, and then public land laws. So when you're operating on Forest Service or BLM lands, there's another layer of federal law that comes in. And then again, where do local governments fit in? So the Constitution, we all might remember from our grade school and high school days, we're a form of limited government. The Constitution lays out what powers the federal government has. Other powers are retained by the people in the Bill of Rights, and we have the 10th Amendment that also lays out the fact that state governments have certain power that the federal government does not have. Two important provisions in the Constitution that come into play when we're talking about federal environmental law and public land law. The first is the Supremacy Clause. There, the Constitution states that this Constitution and federal laws shall be the supreme law of the land. So if there's a conflict, the federal government wins. So that's the Supremacy Clause. And the Property Clause is where the Constitution gives authority over the federal lands and federal minerals to Congress. So Congress can make all needful rules and regulations respecting the territory or other property belonging to the U.S. So what does that mean in the real world? It means cooperative federalism. So the federal government, state governments need to work together. What we'll see as we walk through these federal environmental statutes is that the federal government or Congress has laid out certain standards in the area of clean water, clean air, Safe Drinking Water Act. But then the states can achieve primacy by passing their own law that meets or exceeds federal standards, and then they actually implement the law in the state. You don't have EPA implementing laws in Colorado, Wyoming. You have the state governments with EPA oversight. So ideally, we should have cooperation, the federal, state, and local governments, each operating within their own lanes. It all overlaps and works together. But in reality, we see public confusion and agency turf battles, the tug of war between the state and local communities, the tug of war between the federal government and the state. And the public is confused because, as you'll see when I walk through these federal laws, they cover a lot of aspects, but then there's state laws that cover other aspects. Where do you turn? Yesterday there was a question. Now, who do I call when I have a question about pipeline? Well, there is no simple answer, and that can create confusion and concern that, hey, something's falling through the cracks. Nobody's paying attention to it. So here we have an alphabet soup of federal agencies. I think after you're done with this program today, you'll have heard enough acronyms to last you for your life, but that's the nature of environmental law, is acronyms. You have your land managers, BLM, Forest Service, and then you have your regulatory agencies. And the regulatory agencies implement regulations covering a certain area: wildlife, water, air, wetlands. The public land managers are not regulatory agencies per se, but they manage federal land that they've been given purview over for certain land management goals. So something you'll hear a lot from the Sierra Club and other environmental groups is that the oil and gas industry is exempt from a lot of major federal environmental laws. So we'll just keep that in mind as we go through, and we'll talk about the federal laws, how they apply to the oil and gas industry, and how they don't apply in certain instances. And then I also want to just give you an appreciation for where federal regulation is moving, because it doesn't stay static, and there's a lot of changes that are happening because of the debate around hydraulic fracturing. So we're going to start with our first federal law, the Safe Drinking Water Act. And this is where the frack debate comes out of. So a little bit of history is in order. Initially, there was not much regulation of hydraulic fracturing. As you heard yesterday, fracking has been around for some 60 years. It was a mechanism that was used to recover oil and gas. Not much controversy about it. Little federal regulation, some. State regulators had some regulation, but again, not much. You'll hear later from the Colorado Oil and Gas Conservation Commission, but they play a very important role in the regulation of oil and gas, whether federal or private. So what is the purpose of the Safe Drinking Water Act? It's to protect the quality of water that is being used or could be used for drinking water. Water that's of poor quality, that is brackish by nature, that's not protected by the Safe Drinking Water Act. They're focused on drinking water aquifers underground. So this applies under the surface. And how do they regulate that? They do that through the issuance of permits, underground injection control permits. So if you want to inject something underground, you need to get a UIC permit. And it's a very elaborate process in the sense you look at, is there a drinking water aquifer? Could it be a drinking water aquifer? Where is it being injected? And there's different classes of UIC permits. Class 2 is what applies to oil and gas disposal and enhanced recovery wells. There's a new class that was just put in place, Class 6, which involves carbon sequestration. So if you want to inject carbon into the ground, you would have to get that permit. There's other permits for radioactive injections. And the idea is that this is how people, industries, local governments, et cetera, can dispose of waste. You inject it underground into aquifers that are already in bad shape because they're brackish by nature because of the formation they're in. So this is regulated through the Safe Drinking Water Act, but again, if your state achieves primacy, a legal term, then the state can implement. In some states, for example, Wyoming, the Wyoming Oil and Gas Conservation has Class 2 authority, but their Environmental Protection Agency has other classes. Here in Colorado, we have Class 2 authority. So other states back east, EPA retains authority. So the frack debate starts back in the 90s. We had coal bed methane development. EPA, Carol Browner in the Clinton administration took the position that frack injections are temporary. This is not waste disposal, so the Safe Drinking Water Act does not regulate that. Environmental groups in Alabama challenged that, and they said no. They filed a petition with EPA, said no, the Safe Drinking Water Act requires you to regulate fracking. It's injection. It should be regulated. They won a court case in 1997. The 11th Circuit said yes, the plain language of the Safe Drinking Water Act covers all types of injections. It doesn't say temporary or permanent. EPA in the state still felt that it was not appropriate to require UIC permits for fracking. It's unwieldy, unnecessary in EPA's opinion. And so they came up with a different provision of the Safe Drinking Water Act, the secondary recovery provision to handle fracking, and that was approved by the court. There was a lot of concern among the industry in other states and EPA. What's going to happen? This case was troubling. So EPA did a study of fracking. They found that in the case of coal bed methane, fracking was not a threat to drinking water, but if you use diesel, that could constitute a threat. That resulted in the Energy Policy Act 2005 exemption from the Safe Drinking Water Act for hydraulic fracturing that does not use diesel. This is the so-called Halliburton exemption. But it was not Halliburton. It really stemmed from this case and the uncertainty that was caused by that. What's happening in the future? Our own Congress people, Diana DeGette, Jared Polis, are trying to remove the Safe Drinking Water exemption. They've tried this 5 times and have not failed. They have not succeeded, and they recently reintroduced the bill, I think last week. So the Safe Drinking Water Act also covers injection of produced water. That is the water that comes up out of the formation when you're producing oil and gas, and flowback water. Flowback water is the frack water that comes back to the surface. So these types of water pick up a lot of minerals underground that can be hazardous. In the case of frack water, you have the sand, the chemicals we heard about yesterday. So how do you dispose of that? If you're going to inject it, you need a UIC permit. And you see here the regulations that EPA and the states apply for well integrity, things we heard about yesterday. And then EPA retains authority to come in and investigate under the Safe Drinking Water Act if there's a substantial endangerment that they perceive. So our second act is the Clean Water Act, and this Clean Water Act is focused on surface lands, surface water. And it prohibits the point source discharge of pollutants into waters of the U.S. Now, every single one of those terms is a source of litigation for years and decades, so they all carry a lot of meaning. I just have one case there, one that I was involved in Montana, and that was the discharge of unaltered groundwater during CBM. You might know CBM, you pump water out to release the gas. That water, the Ninth Circuit said, is pollutant. It is a pollutant under the terms of the Clean Water Act because it's used in an industrial process, whether or not it's been changed or not. So that's the type of litigation you can have. Again, you use permits. You have to get a permit that will keep the discharge under the Clean Water Act standards. Again, this is implemented by the states. They issue the permits. EPA sets the standards. And EPA has another tool that they can focus in on particular industries and set standards of how they treat water or handle water, again, to reduce pollution from those activities. And these are important in the oil and gas arena. There's a couple of existing ELGs, effluent limitation guidelines for produced water. They don't want it discharged into surface water. The injection is the preferred handling of it. Western U.S., you can use some of your produced water if it meets certain standards to feed wildlife, livestock, and use in agriculture. That happened a lot during the coal bed methane days. There's a couple of important ELGs that are underway that are a concern for industry, and that is an ELG for coal bed methane discharges, and then shale frack flowback pretreatment standards. So these are coming out in the next couple of years, and there's a lot of study that goes into them before. So now we're looking at other provisions of the Clean Water Act. This is one of the exemptions, stormwater exemption. When the act was initially passed, the construction sites for oil and gas were excluded from stormwater regulation. And stormwater regulation, you should think of it as runoff from parking lots, runoff from construction sites, this type of thing. And they exempted oil and gas when the act was first passed. In 2005, they expanded it in some ways to cover oil and gas construction sites. Again, this is a target of some legislators to remove the stormwater exemption for oil and gas. You have the Spill Control and Countermeasure Rule, SPIC, and that is addressing any kind of oil and gas spills near water bodies. And this is implemented by EPA. And then the wetlands, Clean Water Act Section 404. That is implemented by the U.S. Army Corps of Engineers. And if you're going to impact a wetland, which is a whole nother issue, what is a wetland, you need to get a permit to do so. And EPA has oversight over the Army Corps of Engineers. There's frequently been battles over whether the Corps was right or wrong, and EPA has had to step in. Our third statute, Clean Air Act, obviously regulating air pollution. It regulates it from mobile sources, cars and trucks. We saw yesterday a frack operation involves a lot of trucks and traffic, so that's one thing. And then stationary sources. We saw the compressor stations, dehydrators. Those are all things that have emissions. Again, EPA set standards, these national ambient air quality standards for 6 criteria pollutants. And so not the whole universe of pollutants, but 6 criteria, big major pollutants, NOx, sulfur, things like that, carbon dioxide. And then states develop state implementation plans to meet those standards in the permits that the state issues. Again, the states implement this Clean Air Act provisions. So how will they meet those criteria, pollutant guidelines through their permitting process? Then there's also a hazardous air pollutant provision, and more recently, EPA is requiring greenhouse gas reporting. So an important rule was passed in 2008 on diesel engines. A lot of the equipment used out at an oil and gas site is diesel. And this 2008 rule puts in place new strict requirements that will result in over 90% reduction in NOx and particulates, particulates being dust, which is a big problem in the West because we're so dry. So that adds to our air quality issues. So that's an important rule for new engines. 2012, just in October last year, EPA put in place another new rule focused right on the fracking area. And that is the completion cycle for oil and gas wells, which you heard yesterday. The completion cycle is where fracking occurs. And here you have new source performance standards and national emission standards for hazardous air pollutants. So NSPS, NESHAP is how it's referred to. This is going to apply to the oil and gas industry. And what is it focusing on? This is a problem that, if you were following the news yesterday, was just highlighted, and that is ozone production. We're experiencing ozone up in northwestern Colorado. Wyoming has wintertime ozone. Utah has wintertime ozone. So that ground level ozone is a focus of EPA and state regulators. So this is what this new rule is trying to reduce the emission of volatile organic compounds, VOCs. So requiring certain level of control of equipment. Another big area in the Clean Air Act arena to keep your eye on is greenhouse gas reporting. Oil and gas industry will now have to report greenhouse gas emissions, but the methane question, you might have heard people say, well, if you take into account the methane that leaks out of oil and gas wells and pipelines, then natural gas is not so clean. Natural gas, of course, is 50% less carbon dioxide than coal, so it's considered to be a cleaner fossil fuel. People have attacked that and said, no, there's all this methane, which is also a greenhouse gas, and you need to take account of that, and if you do, natural gas is worse than coal. Well, so that's the issue, and there's a lot of looking into it right now. EPA came out with some numbers on how much methane is leaked. Industry disputed that. Other scientists at the University of Texas, the Environmental Defense Fund, are working together to see, okay, what are the present controls on equipment? What really is leaking? What's the impact of that? EPA recently walked back from one of their estimates of methane discharge because it was based on inaccurate data. So that's a topic that's underway. There's no answer to it yet, but that's an important one to be focused on. But the side benefit of that 2012 rule I talked about is it will be a 25% reduction in methane emissions from oil and gas. So kind of two bangs for your buck. Aggregation is another big issue. It's been a topic here in Colorado. And that is the idea under the Clean Air Act is what is a facility? Oil and gas, as you know, has a lot of dispersed facilities and multiple wells. Is each one a facility, or should you gather them together and aggregate them when you're looking at air emissions? So that's the focus of aggregation. They want to turn oil and gas into a major source as opposed to a minor source. That will up the level of regulation. That's a policy issue at EPA. Jared Polis is putting forth legislation to force aggregation. This has been a long-running dispute on that issue. Okay, so two federal statutes address hazardous waste. One is the Resource Conservation and Recovery Act, RCRA. The other, Comprehensive Environmental Response, Compensation, and Liability Act, CERCLA, or Superfund. CERCLA is Superfund. So this is looking at hazardous waste. RCRA is a reporting statute. It looks at waste from when it's generated, that's the cradle, through how it's used and handled to when it's buried, when it's disposed of, cradle to grave. And when the statute was initially passed in 1980, Senator Benson, a Democratic senator from Texas, said that, felt that oil and gas drilling fluids, produced water, and other E&P waste should not be covered by this reporting statute unless EPA determined it was necessary. In 1988, EPA completed a study and said no, they did not think it was necessary to include oil and gas waste in RCRA. There were other mechanisms that could handle that. We see here in 2010, the NRDC, an environmental group, is petitioning EPA to take another look at that 88 study and reconsider this exemption. EPA is reviewing that. CERCLA, Superfund, think about that as abandoned waste sites. Back in the day when Ford Motor Company, for example, was manufacturing, they just dumped their waste. They put it into landfills, local landfills, and there's a lot of hazardous stuff in there. Who's around to clean it up? This statute was all about shifting the burden of cleanup and addressing these sort of abandoned, orphaned waste sites. That regulates hazardous substances. Oil and gas must report release of hazardous substances, but petroleum products are excluded as non-hazardous. But frac fluid, for example, we heard yesterday there's not really any petroleum products in that. That would have to be subject to CERCLA. EPA also retains investigative authority under CERCLA, and there are also spill reporting requirements that apply to oil and gas under CERCLA. So these two federal statutes, the Emergency Planning and Community Right to Know Act and the Toxic Substances Control Act, they're focused on chemicals. If you're using chemicals, how do you store them? How much of the chemical are you using? And EPCRA, the first one, allows local communities and individuals to obtain that information on the use of those chemicals and spill reporting. So one area that oil and gas E&P sites are exempt from is the toxic release inventory reporting. So you look at different industries and they have to report what they release over the year, and EPA decides what industries go on that list. And 3 times they've looked at oil and gas and decided it should not be on that list. So that, here you see a November 2012 petition from another environmental group saying, EPA, look at it again and put oil and gas under that release inventory reporting. TSCA is a regulation by EPA of the chemicals that are used in a variety of different circumstances. Here, Earth Justice wanted to petition to require EPA to regulate frac chemicals through testing requirements and reporting rules. EPA said, no, we're not going to be testing this. Again, there's other mechanisms to do that, but they would consider reporting on the use of frac chemicals in the aggregate. Earth Justice wanted each use of the chemical to be reported by the individual company. EPA said, no, that's not what they want to do. So we talked about the federal laws and the federal exemption, and I just want to call this document to your attention. This is from the General Accountability Office. It's an arm of Congress, and when Congress has questions about something or they want something audited, this is the entity that does it. In 2012, they issued this report, Unconventional Oil and Gas Development, Key Environmental and Public Health Requirements. And there's a lot of really good information in here talking about what I just went through, giving you resources, bullet points, so it sort of boils it down a little bit, and then talking about how state regulation fits with federal regulation. Purpose of this slide that's hard to read is merely to show they looked at 6 states, including Colorado, and where there were gaps. For example, stormwater permitting. The federal government generally does not regulate oil and gas for stormwater permitting, but in Colorado, you have to get stormwater permits. Pit lining requirements. EPA doesn't have those requirements. 5 out of the 6 states that they studied have them. So again, that's that federalism coming into play. What's coming down the pike in the future? EPA is doing a study focused on hydraulic fracturing and water, Clean Water and Safe Drinking Water Act. How much water is being used for fracking? Does it pose a problem? How is frac fluid and flowback being discharged? what's happening with frac injections, how do you dispose and treat frac fluid. So all the issues that are out there in the public, people are concerned about, EPA is studying those. That report should be presented to Congress in 2014. So here we come to the federal lands. This is another layer of laws that apply to oil and gas when you're on federal lands. So obviously all the environmental laws I just talked about apply, and these are some other additional laws. BLM manages all federal onshore minerals. So if the minerals are under private surface, or if minerals are under the Forest Service, it's BLM that manages those minerals. That's their authority, given under the Mineral Leasing Act of 1920. So one of the issues that I'm sure you hear about in your local government is the problem of split estates, where somebody owns the surface, maybe they've built their dream home on the surface, but somebody else, a private mineral owner, might own the minerals, or the federal government might own the minerals. And how did that come about? Well, that came about in the Homestead era, when the government stopped just giving away the whole top and bottom of federal land to people because of some abuses that were occurring, corruption at the Department of Interior, and they wanted to retain the minerals. And here's a 1983 Supreme Court case that came out of Wyoming. It's a US Supreme Court case, and they explained why the federal government did that. They saw these resources at the time, coal and oil and gas, as valuable to the country as a whole, and the federal government wanted to retain those minerals to manage them for the benefit of the country as a whole. And they did not want to entrust the development of minerals to ranchers and farmers. So a policy decision by the federal government to do that. But what's the relationship between BLM and the state? It's a cooperative relationship. You may hear the Colorado Oil and Gas Conservation Commission speaker talk about that, but there is an agreement, what's called a Memorandum of Understanding, that spells out what does the COGCC cover and what does BLM cover when it comes to federal lands and tribal lands. BLM doesn't regulate largely the downhole activities. That has been left to the Oil and Gas Conservation Commissions. It's spelled out in the MOU. BLM is proposing to issue a new hydraulic fracturing rule. It's expected any day now. And that is a challenge to this historic relationship where states regulate oil and gas operations on federal lands underneath the ground, the downhole, the spacing, all of those things. And so industry is very opposed to this frac law, say, hey, why do we need that? We've got the states regulating it. The states are protective of their turf, and they're saying, we want to regulate this. We have a good track record. Don't change it. So Federal Land Management Policy Act, or FLPMA, that is what's called the organic statute for BLM. That gives BLM its existence. It was in this law in 1976 when Congress said, we are no longer going to dispose of federal land. Our policy now is to keep federal land and manage it for multiple uses. And I think this is one of my favorite quotes on the issue of multiple use, because I think the Supreme Court got it right. Multiple use management, we all use that term, and it sounds pretty simple, but it's really complicated. And why is it complicated? Because you're trying to strike a balance among the many competing uses to which federal land can be put to. Grazing, timber, oil and gas, recreation, wildlife, wilderness. All of these are conflicting, allowed for, permitted uses of the public land, and how do you balance oil and gas with wildlife, or oil and gas with recreation? That's the challenge that BLM and also the Forest Service, under their own separate planning statute, have to apply with. So BLM does the planning in resource management plans, and if you take away anything from today's meeting, it's the importance of resource management plans and your role in resource management plans, or RMPs. This is where BLM decides whether land is open to oil and gas, closed to oil and gas, and if it's open, what kind of stipulations are put on the oil and gas leases to protect those other public land uses. So these are very important. They're public processes. They go through a NEPA process where the public is involved, and local and state government can play a big role in this, bigger than the public at large, if they choose to do so, which I'll talk about. So stipulations are very important. Stipulations are addressed in the land use plan, and those are extra added requirements. You can't go in this area when raptors are nesting. You cannot have any surface occupancy over the minerals. You have to directionally drill towards them. You cannot access the land when elk are calving. All of these are stipulations. They are developed at the land use planning stage, put in the land use plan, and then applied to any federal lease that's issued. So when you buy a federal lease, you need to comply with those lease stipulations. As I mentioned earlier, the Forest Service has similar planning mechanisms, forest planning. The important thing to take away from this is that when the Forest Service manages the surface, BLM cannot issue a drilling permit unless the Forest Service has approved in a surface use plan of operations. So they play an important role on managing the oil and gas activities on the surface, and they have an effective veto over drilling permits if they don't agree with it. So the umbrella over these federal statutes is the National Environmental Policy Act, or NEPA. And some people think NEPA tells the government what it can and can't do. It does not. It's a disclosure statute. The purpose of NEPA is to force the government to stop, look, and listen, take a hard look. What are the impacts of my decision or my grant of federal money on socioeconomics or the environment? So both those things are looked at, socioeconomics being people and the environment being where the people live. So it requires a hard look, and it's documented in documents which have grown ever and ever larger and frankly less and less useful to the public because only someone who's paid to read them. They're so voluminous nowadays, which is not what the Act originally intended. You have your environmental impact statement, which is the most voluminous and thorough document, environmental assessment, or EA, and a categorical exclusion, which is also compliance with NEPA, but it applies to activities that have been looked at many times before. Each time, the environmental assessment result was finding of no significant impact. That is what is looked at in NEPA. Is there a significant impact? If there is, you have to do an EIS. If there isn't, you get what's called a FONSI, finding of no significant impact. And if they've done that 50 times, and CEQ has approved the implementation of a categorical exclusion, you can just use that. You just document, okay, this has been looked at before, no significant impact, and very little documentation required. So here's another important thing on NEPA. It's not a one-time process. You need NEPA when you do your resource management plan. Then you need NEPA when you sell an oil and gas lease, so another layer of NEPA, environmental assessment. You need NEPA when you go to a drilling permit. So if you're going to drill that well, you have to do NEPA again. And then if you're going to really develop the field with multiple wells, you need to do NEPA again. So layers of NEPA, each providing for public participation and comment process, documentation, and of course opportunities for lawsuits too. And here's the important thing. This cooperating agency status. This is something that I worked on when I was in office as assistant secretary, having come from Montana and Wyoming where I lived. I thought it was really important that state and local governments be involved in federal land management decisions. We put in place a rule at BLM, and that requires that BLM invite state and local agencies to be a cooperating agency on any environmental impact statement. So at that level of NEPA compliance, you have the ability to be a cooperating agency. And that means you don't have to sit out there and wait for BLM to issue its NEPA document in draft. You can be behind the closed doors with BLM, or with BLM working on the EIS and providing your input, your special expertise from your state or local government perspective. So there's a desk book that you can find if you go to BLM or just Google Cooperating Agency BLM, and it spells out what your involvement can be. So the other two big subject areas that you have to look at when you're permitting on federal land are wildlife and cultural resources. As to wildlife, that's largely implemented by the Fish and Wildlife Service in the case of the Endangered Species Act. Anytime you make a federal decision, issue federal money, it triggers the Section 7 process. That requires a look at, are there any endangered plants, any endangered species? Is this action going to jeopardize them? So you have to take a hard look at that. It drives mitigation for wildlife. There are several other federal statutes. The Migratory Bird Treaty Act basically covers every single bird except for the starling. So, and you're not allowed to harm or harass birds. So this covers a lot of different bird species. The Bald and Golden Eagle Protection Act. This is an important protection act on top of the Endangered Species Act listing of the eagle that protects bald and golden eagles. This results in these stipulations that I've talked about, the need to survey for raptors, the need to avoid activity during critical times of the year. And then Wild Free Roaming Horses and Burro Act, if you're in an area where the wild horses are living, that's a statute that can apply. The important thing here is, again, this cooperative federalism. BLM manages the habitat. They manage the land. But it's the state of Colorado that manages wildlife. So it's the state of Colorado, the state of Wyoming that has the data on the deer, the elk, how they're using the land, where they're located, when they come to this south-facing slope in the winter and when they don't. And that is where BLM gets its information to develop lease stipulations. So they rely upon the states for that purpose, and when you're looking at the sage grouse issue, where is BLM getting its information for its sage grouse planning amendments? From the state of Colorado, the state of Wyoming. So very important role for the state there, and I think an access point for state, for local and county government is your own state agencies. Second area is historic and cultural resources. There's another process that applies if you're using federal money or making a federal action, and that is compliance with what's called the 106 process. Similar to NEPA, you have to walk through steps, looking at cultural and historic resources. You have to survey for them, very expensive activity. You have to avoid, mitigate. So that's a huge process that anybody operating on federal land has to comply with. There are also special statutes that apply only on federal land. The Archaeological Resources Protection Act, the Native Graves Protection and Repatriation Act, American Indian Religious Freedom Act, all largely focused on Native Americans, the cultural remnants of their history, and their current day religious practices that may involve mountains, water bodies that are located on public land. So as I wrap up here, what do we see going on? At the state and local level in Colorado, cities and counties are passing fracking bans. Now, this didn't spring out of the mind of Coloradans by accident. This is part of a national effort by anti-oil and gas groups to increase the numbers of communities that have imposed fracking bans or moratoriums to help drive legislative and administrative policy change in states and federal governments. So here we see what's going on. Boulder County, there's a fracking ban through June. People are pushing to make it longer. New oil and gas regulations. Boulder City is considering a 1 to 5 year fracking ban. Their own city attorney said, no way can we do a 5-year fracking ban. That's unlawful. But they're looking at it. They said, we don't care. We want you to look at it anyway. New regulations. And here in Colorado Springs, they're trying to get an initiative put in place that will ban fracking and horizontal drilling, which is really kind of amazing to me, because when I was in office, we had a lot of environmental groups come in and say, you need to these companies to do more horizontal drilling. It reduces surface impacts. And so it's like they're throwing the baby out with the bathwater there in Colorado Springs. Be careful of what you wish for. But anyway, so you've got all these different bans, and Longmont is where they have come to a head in the sense of litigation. They put a fracking ban, what passed a ballot initiative in Longmont. Colorado Oil and Gas Association is sued, saying, no, you can't do that. You're taking private property rights. The state has regulatory authority over it. And then they have passed new oil and gas ordinances, which caused the Colorado Oil and Gas Conservation Commission and the governor to come out against them and sue them, saying, no, in Colorado, the state regulates oil and gas, not counties, not cities. So those lawsuits are underway. The result for Governor Hickenlooper, he's got a new name now, Governor Frackenlooper. People are referring to him as too much in bed with oil and gas. Now, this is a Democratic governor who has enjoyed great popularity for his kind of easy manner with people and his just approachability. And here's a quote from a newsman: "He may simply be forced to defend an unpopular decision and go ahead and upset a large group of people." So that's kind of where he's on. And we saw that play out in the legislature. There were 10 bills that came forward in the Colorado legislature this year to add further regulation to oil and gas. He had his people working down the legislature to modify those bills, eliminate those bills. He didn't want to be in a position where he'd have to veto a bill passed by his own party. So out of those 10 bills, 9 went down to defeat. There was one bill he wanted to pass, but he couldn't come to a compromise with the environmental groups, and it was a bill supported by COGA and the governor's office, and that was to increase penalties on oil and gas. So this is an ongoing issue for the governor. So just to summarize from what we talked about, what's the role of local government? You have that cooperating agency role in federal land use, planning, and environmental impact statements. You can be the receiver of information on spills and chemicals. You have the opportunity to work with state agencies because the state influences a lot of implementation of these federal environmental laws and land use laws. And you can have a local land use plan. But when do they go too far? And here in Colorado, you're looking at preemption in the state and county context. They call that operational conflict. This is kind of the same idea. If it's impossible to apply with the state and federal law, or where the local law stands as an obstacle to the objectives of Congress, then that goes too far. That gets us back to the supremacy clause where we started. Congress lays out objectives. They kept those federal minerals. They want to develop them. There's a lot of congressional language to that effect. And if states put in place a ban or a moratorium, that obviously thwarts that purpose. Here are some key U.S. Supreme Court cases on federal preemption. The first one involved oil and gas, where a county wanted to prohibit oil and gas development in California. The Supreme Court shot that down, saying counties can't substitute their judgment for Congress's on the development of federal minerals. Same thing with mining, surface mining. And this South Dakota, this Lawrence County proposed ban on mining was found invalid because it went over the line. Now, where is the opportunity for state and local governments to do some regulation? Here the Supreme Court said there's a difference. If you have environmental permitting, that's not preempted on federal land. They see that cooperative federalism, states can impose environmental permitting. But if it rises to the level of land use planning on federal land, then you can't do that. Again, the Constitution, in the property clause, gives the rules and regulations over federal surface and federal minerals to the federal government, not to state and local governments. So obviously, these are all decided fact-specific, taking a look at the facts. And as you can see, some of these cases are older, and they haven't been brought up again. But I think we may see some of these Colorado cases go on into the federal system. So what's at stake? The International Energy Agency looked at this question last summer in a very important publication on golden rules. Oil and gas people operate with a social license, the consent of the people, as represented in our congressional laws, our agencies. And this IEA pointed out that there is an important point for regulation. That helps build that confidence. Right now, there's a lot of concern out there. Is hydraulic fracturing being regulated? Are there enough regulations in place? And if people lack confidence, IEA said it could halt the unconventional gas revolution in its tracks. And they're speaking from a global perspective. We're not the only country that's looking at the opportunities that fracking brings. You've got China. I think you heard yesterday from your luncheon speaker about the international implications of this. So from an economic point, what is at stake? Some of you in this audience are old enough to remember when the steel industry basically left the U.S. There was no more steel industry. Nobody thought it would ever come back. It's back now. Why? Because of inexpensive, available natural gas. President Obama, in his 2012 State of the Union, called out natural gas as a jobs generator. We see here numbers showing that a domestic job growth from fracking to grow over 30% just in a couple of years. So huge impact on the economy. Energy security. What have we heard since 1974? Energy independence, that our reliance on overseas oil and the danger that puts us in, the wars that we fight over it. Here again, IEA commenting on how the revolution in the discovery of new oil. Here we're talking about the Bakken oil shale in North Dakota, and yesterday the Monterey shale in California. Huge new supplies of oil in the U.S. that no one ever thought. In the mid-20s, we will be completely energy self-sufficient for a couple of years. It's amazing. So first half of 2012, U.S. meeting 83% of its energy need. When I was in office, not too long ago, less than 10 years ago, we were importing 60% of our oil. That has changed with fracking. Okay, clean energy. Remember I talked a little bit about methane and clean energy. Look at this fact. The use of natural gas, subbing natural gas for coal, has resulted in a 4% drop in carbon intensity. We're the only country in the world that has seen its greenhouse gases go down. And that's a result of natural gas. So, and also look at the benefit on the bottom there. Lowest emissions of CO2 and NOx in 20 years. Lowest carbon emissions since 1994. Again, all because turning to natural gas. So those are the benefits. We talked about the regulatory structure in place. So where is this oil and gas regulation going? What role will the federal government play? We've got EPA, BLM, taking a look at more regulation of fracking. But you see in the states, continued improvement, more regulation of oil and gas. Right here in Colorado, 2009, we had a big rulemaking. 2012, they came back, put in a frac disclosure provision. So there's always changes. Local governments, on the other hand, are trying to ban fracking and horizontal drilling. So you're going to see a lot of activity in the form of legislation, citizens' initiatives, lawsuits, and I think that will resonate down in your local communities as well. And I think what you're doing today is an important part of what you can and should do, and that is be educated on the issues. Certainly people come to you as leaders in your community for information, and coming here today and yesterday to learn about this is helpful. I wanted to leave you with some resources that you can go to from the government on questions involving hydraulic fracturing in oil and gas, COGCC's website. EPA has a good website on hydraulic fracturing, and then the Interstate Oil and Gas Conservation Commission, that's the group of all oil and gas conservation commissioners. University of Colorado, the board that I serve on, Center for the American West, Professor Patty Limerick is hosting a series of lectures, fracking experts, proponents, opponents, every Tuesday night up in Boulder, and they have been memorialized in podcasts. So you can go there and listen to podcasts by people that are looking at the question of what do we know about fracking, what don't we know, and what should we do? And then you have industry websites and NGO websites. So I think this gives you some sources, and I'm ready to take any questions that you have.
Questions?
Thank you. Great presentation, and I have lots of questions, but I'm going to limit it to one.
On the issue and kind of reflecting some of the comments and concerns that we're hearing from our constituents in Elbert County, and I'm the commissioner there, so I'm hearing a lot of the public's concerns. On the issue of VOCs and air emissions, and we talked about air testing as something that's being looked at or done for to kind of address that concern. Why, and first of all, in an area like ours where we have 100-mile-an-hour winds most of the time, and it's hard to understand how that would be productive or really would address the issue. Why don't they go to the regular, the way that most industry does, and take those MSDSs times the VOC times the usage, and do they have to keep those kind of records to talk about the kinds of emissions per tonnage, based upon the actual amounts and what they're using at the different sites?
Well, I think the way EPA is approaching it is they're coming up with requirements that you have to meet. So it's a rule. So rather than so much record keeping, it is setting a standard. And there are engines, what are they called? Class 2 drilling engines, Class 3, which meet certain requirements. This will force companies to move from a number 2 level drilling to others. And it is a way to address a problem that has been identified in several states, this ozone, and they don't really have a lot of information on it. It is a regional problem, like you point out.
But just from a realistic point of view, you're talking about the equipment running and all those emissions and coming out of the tailpipes. Quite frankly, I don't know that people are really focused on that. They have this perception that the chemicals, which we all know are not as bad as most people perceive that they might be, that the actual usage of the chemicals that go into the fracking process and any other things that are used on site, quite frankly, I think it would behoove us to put that into the standard formula that's used in general industry, and I think it would show, or even be reassuring, if you would, about that there's really not many emissions taking place there.
Yeah.
Just a thought.
Well, I would just say that 2012 rule I talked about gets at that control of the chemicals that are emitted during the fracking process. And that rule was just put in place, so that's new. And as far as the details, I can't say. Just as I said, this is sort of a high-level discussion of these rules. Each of these areas are areas of expertise, and I'm no Clean Air Act lawyer. There are a couple in town in Denver that are, and it's a very regulatory, numbers-driven, scientific area, and it is difficult.
Thank you.
Yes, sir.
Hi, Rebecca. I'm Matt Lepore. I'm the director of the Oil and Gas Commission. Thank you. It was a very informative presentation. I actually just want to make a couple of comments,
Sure.
and then I may have a question in here too. But, virtually every public meeting that I go to, somebody, a member of the public, stands up and says, oil and gas is exempt from the Clean Air Act, the Clean Water Act, and NEPA. And so thank you for making it clear that that is simply not true. And I would like everybody in this room to understand that that is not true. NEPA applies to oil and gas the same way it applies to every other industry. That is, applies on federal land. It doesn't apply on private land, but that's how it applies to everybody. So I wanted to reiterate that. I also wanted to highlight that with respect to EPA's new new source performance standards, under federal law, those would take effect in 2015. The Colorado Department of Public Health and Environment, who regulates air emissions in the state, is undertaking rulemaking right now to accelerate the adaptation of those new standards. So CDPHE's goal is by the end of this year to have new rules in place that would accelerate those EPA standards. I also wanted to point out that the BLM frac rule that we expect any day now, large parts of that were modeled on existing Colorado rules. All right, so Colorado does have a reputation as being a leader in regulation of oil and gas, especially around these environmental issues. And the frac fluid disclosure rule that Rebecca alluded to that was adopted in December 2011 is one of those areas, and it does require some of this inventory keeping that the commissioner was alluding to. I actually did learn something that I didn't know. I did not know that oil and gas is exempt from the toxic release inventory reporting, so that was news to me. So I think that's it. I just wanted to add
Yeah, I
those
appreciate
things.
that.
Thank you very much.
Yeah, that kind of illustrates that cooperative federalism that I'm talking about, the important role of state and federal governments working together and filling in gaps.
Thank you. Very informative presentation. Thank you. I'm curious, once, let's just say you have a surface spill, what federal laws all of a sudden go into effect? What agencies start to get interested at that point? And what sort of wheels turn in motion at that point? Let's just say it's a large spill,
It's-
like the one over in, I think it's Parachute, or I think that area.
Right. Well, I would start first by pointing out that state law, the one piece of legislation that did pass reduced the amount of spill that had to occur before you had to report for the state. So the state would have a role under the Clean Water Act. If it's near a water body, you would have EPA involved in that SPCCC law. And also under CERCLA, there could be coverage under that statute. There's another statute called the Oil Pollution Prevention Act that was passed after the Exxon Valdez spill. I think that's another, but again, that's EPA. So it's complicated. All these federal statutes, some of how they apply or don't apply depends on the amount. But I would start first with COGCC. If you had a spill in your community, I would call them first and say, this is what we have, this is what we know, who should we talk to? And get them to help steer you to the right person. Because if one thing I've learned in doing federal environmental law, it's getting to that one person that really knows what they're talking about. So that's 90% of the battle, and you may have to call a number of people to get that person. Yes, well, there he is. He's here. I don't know. I think that might just happen on TV. No. I would say you'd have your state and probably EPA. I've not had an experience where I've been standing by a spill and seen who showed up, but perhaps Matt can fill us in.
Representative, I apologize. I actually missed the premise of your question, but if the question is if there's a spill on an oil and gas location, who shows up? Most operators have a pretty sophisticated emergency response plan of their own in place. So their SWAT team shows up. They always call the local emergency responders. So the local emergency responders show up. They call us. We don't have emergency vehicles and 24-hour, standby people. We are usually on scene within, I would say, 12 hours. What we'll send is either one of our field inspectors or one of our engineers or one of our environmental protection specialists or some combination of all three. I didn't really come here to talk about the spills and accidents that have happened recently, but we've had a couple. We had two in Weld County. We had one from Anadarko, one by a company called PDC, sort of well loss of control situations that, they would warrant sort of an ET response. There's fluids shooting into the air out of a hole in the ground, not a situation you want. Both of those situations were handled remarkably professionally and remarkably quickly. Fluids were contained, the wells were taken under control, people were notified, county commissioners were notified, we were notified. Those two situations happened about as well as you could hope that they would happen. Does it always happen that way? No, not always, but there's a pretty good track record. Some of the things that have resulted from those two particular incidences are a lot of communications about how to better communicate. We have a situation in Parachute that most people in this room know about. There was, a lot of talk about how do we make sure all the potentially affected local communities find out, and how does that chain of communication get developed? In that particular instance, the minute I found out, I made calls to the Parachute water management person to make sure he knew, and I made calls to Garfield County to make sure they knew. They both already knew and had carried on that communication line.
just real quick, could you explain what happens on an Indian reservation? Where does this federal, what are the rules when you get into a reservation? Who is in control? What laws do you follow?
Well, on an Indian reservation, the important thing there is that they are sovereigns. They are co-equal with states. So they do not have state regulation largely on Indian reservations. Many Indian reservations have their own tribal environmental codes, but in large measure, federal law applies to Indian reservations. Provisions under the Clean Air Act and Clean Water Act allow states to assume tribes to assume regulatory authority over implementation of those programs, similar to what states do, but that has been very slow in developing. Some tribes in New Mexico have that authority. Tribes as states, it's called TAS, another acronym. So you have that. Again, the Bureau of Indian Affairs and BLM and what used to be called the Minerals Management Service all play a role on Indian reservations. EPA does, DOE does. So there's a huge federal footprint there, which a lot of tribes would rather not have. It's a lot more difficult to do things on reservations. And so there's been a movement over the last decade, I would say, for tribes to try and assert greater sovereignty and control and get the paternalistic federal government out of their reservation, but that's a process. Yes, sir.
Hi, Rebecca. I'm John Baza. I'm the director of the Division of Oil, Gas, and Mining in Utah. And maybe to help Matt with addressing the question about spills, it's very similar in Utah, but I would say that the response to the spill depends on the conditions of the spill. Some spills are very small, and likely you're going to see a measured response to that, where not many people show up, and the operator just cleans it up, and it's simple reporting. But a lot of conditions apply as far as, did it reach a waterway? Is there a public safety problem? Do we need to evacuate people? So the response to a spill will cross the first responders at the local level, the state level, and even the federal land managers, depending on who has to be involved. The question I had for you is, you brought up on one of your slides, and I think it was related to the BLM frac discussion, but you indicated that there is a little bit of turf protection debate going on between the states and the federal government on that. And I'm going to put on my state hat and my Interstate Oil and Gas Compact Commission hat and just say that, you know, when I've had discussions with my counterparts at the BLM, I do sense a lot of turf protection on their part. I do sense that they try to throw out that federal sovereignty clause very quickly. Whereas from my point of view, I'm just looking at it from the standpoint of efficient government. It seems like at the state level, we've been able to manage fracking in the states. We're evolving with our fracking rules. We're going to respond accordingly to the needs of the public. And that if I were a taxpayer, I would want to ensure that my tax dollar is going to get the best bang for the buck. And I think, frankly, that is at the state level. So my question to you is, do you think the concept of federalism is really catching on at the Department of Interior or at the BLM level? Or is it just an idea that people talk about?
I think it is, you see it in some instances and others you don't. And I think in the fracking area, President Obama himself, in the 2012 State of the Union, said he wanted to see a fracking regulation on public lands. I think you would hear from Secretary Salazar, the last Department of Interior, and the President, that they think this fracking rule would be beneficial because it would act as a shield against the opposition to fracking. This administration, although it has been adverse in a lot of different separate instances on oil and gas regulation, largely sees the self-evident fact that oil and gas produced domestically is good for the country, good for the recovering economy. So they're not opposed to oil and gas development. They're worried about the frac debate. That's their rationale for putting in place a federal frac rule. I think the states have a good argument. They've been regulating it. They're responding to the same public concerns by increasing the protection and the disclosure. And there is no good reason why the states shouldn't be able to continue regulating fracking. BLM's perspective is, wait a second, these are federal minerals on federal land. They're leased by us under the Mineral Leasing Act. We have all the authority in the world to regulate oil and gas operations on our federal minerals and federal land. So there are two sides to that. As in any federalism debate, it's a tug.
Okay, one last question.
Yeah, I just want, my name's Julie Westendorf. I'm a La Plata County Commissioner here in Colorado, and we have a lot of coal bed methane development in our county. And I just wanted to delineate the difference between a ban and a moratorium from a local government perspective, and that is that moratoria, I think, are a very useful tool for a local government to buy some time to get appropriate regulation in place versus a ban, which my understanding says we're not going to talk about regulating it, we're not going to do it. I understand the Longmont situation is a ban on the development. I mean, while Boulder's situation is a moratorium, and they have at least drafted some regulations that they will they think will help their county deal with a new kind of high-impact development. And so I just want to clarify that there's a distinction between a ban and a moratorium. Our county did not put in a moratorium regarding fracking because we felt like our oil and gas regs already protected the community and were adequate, but just wanted to make that distinction.
Yeah, and I think in the case of the Boulder example, it's a good place where those distinctions which you made are correct, blur. In Boulder, they had a 6-month moratorium, then it went to another 6 months to June, and now people in the public are arguing, just keep extending that moratorium, so then it in effect becomes a ban. And in the city itself, they're talking about a 5-year moratorium, and rightly, their own attorneys pointed out, that won't pass the straight face test. That's more like a ban, which is prohibited, and not a moratorium. So I agree with your point that there is a distinction between those two things.